All rise. The Honorables, the presiding Chief Judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you. Good morning and welcome to your North Carolina Court of Appeals. My name is Chris Still and I'll be presiding today. To my right is Judge Toby Hampson. To my left is Judge Tom Murray. I'd like to thank Roderick McFarland for being our clerk today and Officer Tom Salute for being our marshal today. Thank you for being here. We have one case on the calendar. It is State versus Jacome. Am I saying the name right? State versus Jacome. And if you're ready to proceed, you can begin. And let me know if you want to reserve any time for a rebuttal.
Thank you, Your Honor, and may I reserve 5 minutes for rebuttal, please?
Certainly.
May it please the Court, my name is Janine Fedor from the Center for Death Penalty Litigation, and I represent the defendant appellant C.J. Jacome in this appeal. This is a very troubling case. Mr. Jacome is serving life imprisonment without the possibility of parole for a crime that it was almost physically impossible for him to have committed. Instead of a brick and mortar case based on physical evidence, the state presented a digital case, including voluminous amounts of hearsay text messages whose meaning is not at all self-evident, and cell phone data obtained in violation of the Fourth Amendment, and much of which the defendant did not have a proper opportunity to confront. The state's case, I submit to you, is a straw house. It looks solid from a distance, but if you get close enough to start to pull on those straws, that whole edifice starts to collapse. This morning, I would like to address Issue 3 in defendant's main brief, which was the unconstitutional search of the defendant's cell phone. I would also like to address the illegal search that resulted in the collection of Mr. Jacome's cell phone location data and the Confrontation Clause violation that arose from Mr. Agent Harrison Putnam's use of that data.
So you don't make any argument that there wasn't enough evidence to convict. You're just arguing that a lot of the evidence that came in should not have been heard by the jury. And without that evidence, there's at least a prejudicial effect.
That's exactly correct, Your Honor. I did not make a sufficiency argument in my brief. I believe you can certainly make an argument that the state's evidence is sufficient. But when you start to look closely at that evidence, it in fact is quite weak. And of course, much of it was illegally obtained. And I believe that the weakness of the state's case, when looked upon closely, is really what supports the prejudice argument behind many of the arguments that I will make today and otherwise made in my brief.
Okay, so there was a lot of circumstantial evidence that pointed to his guilt, perhaps. But which evidence do you think should not have been heard by the jury? So I think that's what you're getting at.
Yes, okay. Your Honor. Thank you. That clarifies my argument beautifully. So the first evidence that should not have been heard by the jury was the evidence that was collected by the extraction of the entire contents of Mr. Jacome's cell phone through an unconstitutional search. What happened in this case is the digital equivalent of the police knocking on a person's door with a warrant that permits them to take everything. Every piece of paper in a person's house, all their photographs, all their books, their entertainment collection, their personal correspondence, their financial records, their travel records, their purchasing history, and dating me, their Rolodex. That's exactly the kind of rummage or unconstrained search that the Fourth Amendment prohibits. Extracting the entire contents of a person's cell phone cannot possibly meet the particularity requirements of the Fourth Amendment or Article 1, Section 20.
What about the language of the search warrant? Was that sufficiently particular?
No, Your Honor. I think it is the warrant on its face that is overly broad. And the warrant on its face says basically that the state is looking for data. And data is a broader term than the word contraband, which the Supreme Court criticized in Groh versus Ramirez. I mean, data includes everything on a phone. And the only way that that word was qualified, even in the affidavit and in the warrant itself, is data related to an investigation into a missing and endangered person. Well, a missing and endangered person is not a crime. And the only thing that you're permitted to search for under the Fourth Amendment, remember, this is a state intrusion on personal privacy. And that intrusion, the ability of the state to intrude on a person's privacy, is limited constitutionally by the Fourth Amendment.
Well, that was a question I had. So was this search warrant issued before they had even identified any crime had been committed? It was just a missing person. Am I reading the record correctly?
Yes. Your Honor, it's a little more complicated than that because there were 2 warrants and 2 extractions. The first warrant, yes. The first warrant was done on December 4th, 2020, before they knew that there was a homicide, and the warrant alleges only that there is a missing and endangered person. Now, after...
Can a warrant be issued when there's a missing or endangered person?
No, Your Honor, because a missing and endangered person is not in itself a crime. There could be reasons that a person might be missing and endangered that does not involve any criminal activity. For example, Mrs. Montgomery, immediately after her daughter's disappearance, remember that Emily Montgomery, the victim in this case, suffered from a substance abuse problem. She was a very, very serious alcoholic. And it was late November, and the temperatures at night get below 30 degrees. She may have been concerned about her daughter passing out from alcohol use and suffering from hypothermia, or being the victim of an accident because she lost her balance due to being intoxicated. Those would be reasons for a person to be endangered that have nothing to do with the possibility of criminal behavior leading to her injuries. Now, just to follow up on my earlier answer, Judge Dillon, there was a 2023 warrant. So after the defense counsel filed a motion to suppress the 2020 warrant, the state went back and got another warrant signed in June of 23, almost immediately before this trial occurred. And in that warrant, they modified the reason for the search to missing and endangered person / murder. And obviously, by that point, they believed that Mr. Jacome had killed Ms. Montgomery. But I would submit to you that missing and endangered / murder can be read in the disjunctive, and that too is overly broad. But most importantly, with respect to the 2023 warrant, it still doesn't satisfy the particularity requirements of the Fourth Amendment. And if you look at the language in the affidavit prepared by Detective Burns, which I quoted in my brief, he describes all of the things that can be on a cell phone, and it's all of the things that I just read that could be in a house. It's financial records and correspondence and details about where a person has traveled. And it's like, we want to search this cell phone because there's so much information on cell phones. That doesn't curtail the search. That doesn't meet the requirements of the Fourth Amendment.
Can you talk to me a little bit about the interplay of the 2 warrants, 2020 and 2023, particularly from a legal standpoint? So even presuming the 2020 warrant was invalid, does the 2023 warrant kind of cure any invalidity there?
No, Your Honor, I don't believe it cures the invalidity. I would concede that the 2023 warrant does improve the 2020 warrant by adding that word murder. So there really is no crime at all in the 2020 warrant. Obviously, murder qualifies as a crime. However, there simply is no limitation on, I would say murder answers the question of why they are looking at the phone, but it doesn't answer the question of what they're looking for on the phone, and it doesn't answer the nexus question of why they believe evidence of this murder might be on that phone. And those are the particularity requirements that are imposed by the Fourth Amendment by Article 1, Section 20. And I would also point out that if only the 23 warrant is valid and the 2020 warrant is not, the seizure of the phone in 2020 becomes unconstitutional. You can't seize a phone, which they did without a warrant, and they I didn't challenge that because they obtained a warrant the next day, and that seemed reasonable. But to take a phone and to hold on to it for 3 years and then search it seems to me to make the seizure unconstitutional. So Judge Ridgway found that both warrants were valid, but I believe if you strike the 2020 warrant, not only is the 2023 warrant on its own unconstitutionally vague, but also it raises questions about the seizure of the phone itself.
Is the defendant challenging the findings of fact that the trial court made?
No, Your Honor. There's one finding of fact in there that I would take issue with. Judge Ridgway found that Mr. Jacome had a prior history of assault on a female, inflicting serious injury. If you look at defendant's motion of in limine right before trial, that assault charge had not only been dismissed, it had been expunged. Now, Judge Ridgway doesn't find that Mr. Jacome had a conviction for assault with a deadly weapon. He uses the word history, and so I didn't feel like there was sort of clear and convincing evidence that that was a misstatement of fact, but I think it's a mischaracterization of Mr. Jacome's criminal history.
And so if you're not challenging the trial court's findings of fact, how does that impact our review here?
Yes. There are two conclusions of law, Judge Murray, that Judge Ridgway makes that I would argue are reviewable de novo as conclusions of law and were incorrect. And the first one is that Judge Ridgway finds that the phone is an object. And a phone is not like any other object. And that's, if you look at California versus Riley, Riley versus California, the case where the Supreme Court finds that you need a warrant to search a phone, the state made the same kind of argument. They argued that a phone is akin to a purse or akin to a pocket. Riley had to do with whether or not the police could engage in a search incident to arrest. And the Supreme Court said that a phone is no more like a purse or a pocket than a horseback ride is like a trip to the moon. So a phone is much more analogous to a premises. It's much more analogous to a house where all of your belongings are stored than it is to an ordinary object. And not only has the U.S. Supreme Court said that, but this court said more or less the same thing in State versus Ladd. State versus Ladd had to do with whether or not a search exceeded the extent of consent, and in that case, the state had searched beyond the consent granted by the suspect an external hard drive. And the state in that case argued the external hard drive was just like a container. And this court said, no, an external hard drive is not just like a container. An external hard drive, like a phone, is an amalgamation of a huge amount of information. The ultimate question under constitutional, both the federal and the state constitution, is the issue of reasonableness. And it's simply not reasonable for the state to extract every single piece of information from a person's phone.
Was the phone, did the phone have, what was the damning evidence on the phone? Was that where he did the search, how to get rid of a dead body or decomposing body? I mean, that was pretty damning. And you're saying none of that should have come in?
That should not have come in.
Or was there location evidence that he went to go visit the site where the victim was buried? Was that on the phone too?
That there was GPS location data on the phone. And in addition, remember that what was on that phone were all of the text messages between Mr. Jacome and Emily Montgomery that were then used by Sergeant Ottaway to present expert testimony that they had an abusive relationship. I also, in the brief, challenged the legitimacy of Sergeant Ottaway's ability to give expert testimony on that question, but that was another piece of prejudicial information that came in through that search.
So, but even kind of analogizing it to the search of a house.
Yes.
Under assuming a valid search warrant, within that search warrant, the law enforcement is authorized to search the entire house for items listed in the search warrant.
Yes.
Why is that any different from a phone in that standpoint? The ability to search the entire phone looking for evidence of items
Yes.
listed on the,
If the state had, or if the police had listed items they were searching for, I think that would make this warrant much stronger. But they didn't. They didn't limit it at all. They didn't say, for example, and I'm undercutting my prejudice argument a little by arguing this, but if you look at Judge Ridgway's order, I think what he proposes might have been a reasonable search. He says that there were 2 items of evidence on the phone that would have been probative of whether or not the defendant had committed homicide. Pictures of the victim to show her identity, and communications between them to show their relationship. If that had been itemized in the search warrant, we're looking for communications between the defendant and the victim. We're looking for photos of the victim, and the search had been throughout the phone, although phones are a little bit different than houses because they're segmented into files and file types. But if that had been the items that they were looking for, I'd have a lot harder time arguing to this court that that was an invalid search. The problem with this is that the only item that's listed is the phone itself. And that, because a phone is not an ordinary object, not a simple container, was simply overly broad to meet the requirements of the Constitution.
So if the request is overly broad, like I'm thinking of a house analogy, and let's say it would only be permissible to search my bedroom, but the warrant application says go search the whole house, and the judge says you can go search the whole house, but in my bedroom is where they find the damning evidence. Is the whole thing thrown out just because they didn't particularly say bedroom? Is there any prejudice there? Does the fact that the application, everything is overly broad, throw out the whole thing, even though the thing that was being searched for, if they just listed that specifically, it would have been okay? If they put bedroom, you're saying it would be okay. But the fact they put house and they found it in the bedroom, does that invalidate the entire what's found, or is that just kind of a harmless kind of thing because they didn't identify bedroom in the application?
I believe if they had identified bedroom in the application and
but they didn't. And let's say the bedroom is the bedroom is the only place that the Constitution would have allowed them to search.
Okay, yes.
But they say house.
Yes.
And the judge signs off on the warrant, and they go search my whole house, but they find the damning evidence in my bedroom, which would have been okay. Is that search bad? Or can that evidence come in if they find it in the bedroom, which would have been permissible if they just narrowed it to that?
I think you are arguing or presenting a prejudice challenge, Your Honor. And
so why not here? Wasn't it okay to look at the text messages? Because you said the text messages would be okay, and if they just simply listed it, but that's where they found the damning evidence. So why is there any prejudice here?
Yes. Well, that's why I said I am sort of undermining one of my own aspects of my prejudice argument to say that I believe that had Judge Ridgway's description of what was looked for been complied with, my argument would be very different today and a lot weaker. But remember, it's not simply the information in those text messages that is the prejudicial information.
So what room did they go in on the cell phone that you think they should not have been able to go into?
His deleted
that had the
internet
damning
searches
evidence.
that had the damning evidence. And the GPS sites. Remember, they already had his cell phone location data. So and they never say we're looking for GPS coordinates on a particular time or date. So that wasn't included in Judge Ridgway's description of what would be probative of a homicide.
They had her cell phone where she was, right?
That's correct.
Were they investigating whether or not he was involved at that time? And wouldn't it be okay to look at his GPS to figure out was he with her at the same time? Why wouldn't that be a room to go into that would be okay?
Yeah. Well, it might have been, Your Honor, if they had listed that as a room, but they didn't. And remember, by the time they did
that's my
search,
bedroom analogy.
Yeah.
You said that's not prejudicial. It's not
Yeah.
prejudicial. If it was okay for them to go in that bedroom just because they didn't specifically list it, why is that prejudicial?
I believe that it is that you're still looking at an invalid warrant when they're asked to look for everything. And I think that where you and I may differ, and perhaps we just have to leave it there, is whether
I'm just asking.
Yeah.
I don't know.
No, I completely understand.
I'm using your house
Yeah,
analogy.
yeah,
So I'm just trying to understand if that's the rule that you don't have to list bedroom and they find it in the bedroom. If that's okay, why is this different?
I think that a closer analogy to what you're saying is that the bedroom is described in the warrant, and they find prejudicial information. Like, they should have searched the attic. You know, they should have realized that there might be something in the attic, and if they listed the attic on the warrant because they find something in the attic, then there's no prejudice. It's just so hard to engage in that kind of hypothetical reasoning, that if they had probable cause to believe that there's GPS information on that phone that would be probative of the homicide, you have to know that before you complete the warrant. You can't just retroactively justify your warrant by saying, look, we found evidence that we can use. You've got to have probable cause before you complete the warrant. And there's simply, no matter how you cut it, you can't get to searching deleted internet searches, which was probably the most damaging evidence that was introduced as a result of this search.
So is it your argument that the four corners of the search warrant does not contain enough sufficient particularity to have probable cause? So there's no probable cause issue that you see on the four corners of the document?
Particularity is an independent requirement to probable cause. I mean, they're related, obviously. It's hard to do a probable cause analysis unless you can identify with particularity what you're looking for. And because there was no itemized, there was no list of what the police were looking for, it's hard to do that nexus analysis. Why do you have probable cause to believe that this evidence of a crime is going to be located on that device?
If I've got an endangered person,
Yes.
and the search warrant says this was the last person they were with, and I've got evidence from a friend of that person who says she's concerned about her safety, is that probable cause in the four corners of the document?
Well, Your Honor, you started by saying you've got an endangered person, and an endangered person, as I said earlier, is not in itself a crime. So, what do you think has happened to that endangered person that makes that person a victim of the crime? And then how do you identify itemized objects or data that might be on that phone that would relate to whether or not this particular individual committed that criminal activity? They don't go through any of that with this warrant.
In the first warrant, did they have her locations and all that? They had her phone?
By the time they did the first warrant, they had both. I am running short of time here, Your Honor, because
move on.
Yeah, I do want to point out there is that other bad search, the search that resulted in the cell phone location data, which they did have by the time they do the extraction of his phone. And that's where they use the SCA order, Secure Communications Act order. And it's plain error argument in the brief. There was no objection to it, but I did include it as an ineffective assistance of counsel claim in the MAR. And that SCA order does not begin to meet the requirements of Carpenter. Carpenter was decided 2 years before this SCA order was issued. And both Carpenter and this court in Gore says an SCA order, if you're going to use that apparatus, which you probably shouldn't, because warrants have to be served, has to meet the requirements of a warrant. When they issued that SCA order, that was just a few days after.
Was that the evidence that showed where he was?
Yes.
Not on his cell phone, but the cell phone didn't show that information. You're saying where he was.
There were two GPS coordinates on the cell phone, one of which seems to be an error, Your Honor, because if you look at the underlying data, you can't find that data point, but there was one GPS coordinate on the phone they extracted from the phone that showed Mr. Jacome close to the burial site at 5:22 p.m. on December 27th, which was Friday. I think, honestly, that's equally consistent with him driving along 540 at that time, which abuts the gravesite, and he checks out of Walmart at 6:30 p.m. on the same day.
But you're saying the other evidence is more detailed.
The other evidence is the cell phone location data, which alleges, I think, again, incorrectly, that's where I raised the Confrontation Clause issues, that he was at the gravesite in the middle of the night. That's much more damaging evidence than him possibly driving by when 540 abuts. So I think that cell phone location data was absolutely critical to the state's case, and that SCA order, it doesn't have anything akin to probable cause. And again, at that point, just a few days after her disappearance, this is a young woman with a substance abuse problem. The last thing she tells her mother is that she needs to go to rehab, and omitted from the affidavit that Detective Davis completes for that SCA order, he doesn't say in that affidavit that her phone records show that after the last time they had her with Mr. Jacome, she goes home, and then she goes to Wake Met. So that seemed perfectly consistent with her going home and her mother taking her to a rehab, or her getting an Uber to a rehab, which she said she needed. So that's the last time they had their phones together at the time they got that SCA order, was when the phones were at his house. It's not until they get his phone records as a result of this order that they see that their phones were together for longer than he had claimed initially. So there really is nothing at the time they get that SCA order. And again, the allegation is investigation into missing and endangered person, which is simply not a crime. So if that first search was invalid, and that search then is used as part of the probable cause affidavit for the second search, then all of this cell phone evidence, on which is the core of the state's case, was all unconstitutionally obtained, and Mr. Jacome is entitled to a new trial.
Thank you. Now, we hear from the state.
Thank you, Your Honors. May it please the court, my name is Rob Ennis, and I'm with the North Carolina Department of Justice, and I represent the state in this matter. My colleague on the other side has raised several claims in both the brief and the appellate MAR she's filed, but all of them suffer from the same fatal defect that even if she has shown error, which she has not, there's no way that she could establish sufficient prejudice. My colleague has indicated that there is not sufficient physical evidence in this case. I just want to very briefly go through some timeline of physical evidence. We can even ignore the cell phone evidence. We have evidence establishing a history of domestic violence relationship between the defendant and Emily, not only from the cell phone texts, but from about 6 witnesses testifying to physical abuse suffered at her hands from the defendant, including black eyes and trips to the hospital. We have the night on Thanksgiving, the defendant 3 times initially lies to police and says the last time he saw Emily was after he drove to his mother's house, and then she decided to stay in the Jeep, and then when he left the Jeep, Emily vanished from his Jeep, and that was the last time he saw her again. We have the text messages from Emily and her friend the day of Thanksgiving where she says she and the defendant aren't getting along, and she's going to kill him before he kills her first, and then the very last text that she sends her friend is, "It's going to happen, he's going to kill me." We have, despite...
Well, first of all, how do we know it was a lie, that he lied when he said the last time he saw her was at his parents'?
So we know that's a
But
lie,
for
even
the
without his cell phone evidence, because the state was able to get the CSLI data from Emily's cell phone, which tracked her location going southbound on 540, which is the opposite direction of the defendant's apartment, and an image from the Highway Patrol, the Turnpike Authority, depicted the defendant's vehicle traveling that same location and time at 10:22 southbound down I-40 when he told police that he just went right home from his mother's house on Thanksgiving, which was the opposite direction. In addition to that, the very next morning after Emily's disappearance at 6:45, the defendant goes and buys a car wash. He then goes to Walmart and buys cleaning supplies, shower liner, a shovel, and garbage bags. Then, if we put aside the GPS fix at Emily's gravesite at 5:20 p.m., we have the defendant going back to a second Walmart where he buys more cleaning supplies, including 4 bottles of Clorox bleach. From there, he goes right to a second car wash of the day where video surveillance shows him meticulously cleaning the exterior and interior of his vehicle for 2 hours And after that, the defendant goes to another Walmart and buys more trash bags. Now, if we were to add the cell phone data there, we would be able to track, well, after that night is when he Google searches for the first time, which he then later deletes from his phone, body chopped into pieces. That's around 12:45. About an hour later, his GPS from the cell phone search, his phone registers a GPS fix within feet of Emily's eventual gravesite. Following that, the defendant searches what time is the sunrise in Raleigh. This is around 4 o'clock a.m. And then later that day, he searches and then deletes from his phone how long for a body to decompose in dirt.
I understand there's a lot of damning evidence, even apart from the cell phone. But if they objected to it, isn't our standard, is there a reasonable possibility that one juror might have had a reasonable doubt, but for the fact that they saw all this stuff on his cell phone, how fast does a body decompose and where he was at the gravesite? It's just that's all the standard is. And so if that evidence does get thrown out, why isn't there at least a reasonable possibility, if they objected to it? I assume they objected to all that. They didn't object. I know they got plain error review on one of them, though.
That's right. They did not object when the cell phone CSLI data came in, so that's reviewed under plain error.
And that put him at the gravesite at certain times. Is that correct?
So the CSLI data actually put him at the gravesite for about 3 hours the morning after Emily's disappearance. And mind you, the gravesite is in a secluded field surrounded by woods off ACC Boulevard. But what's more damning, in my view, than the CSLI data, well, the fact that he was there for 3 hours a day after her disappearance, where she was eventually recovered about 22 days later with 32 stab wounds in her body and transected or cut in half at the torso. Aside from that, the cell phone data shows GPS fixed location, which there's evidence to suggest that's the most accurate location data that there is within mere feet of Emily's eventual gravesite.
But I found it interesting the way you framed those facts, because I think, the first piece of it, the trips to Walmart, I think your colleague would concede that is in fact some circumstantial evidence, but that's what it is. It's circumstantial. And then, interestingly, then you bolster that by adding in the CSLI data, the cell phone searches, that kind of stuff. And so isn't that the point? That without the CSLI, all you have is the circumstantial evidence. And that's why the introduction of this other evidence would have, in fact, been prejudicial.
Well, Your Honor, going to your first point, I think, there's additional evidence I didn't talk about, which was the fact that he bought a full-size shovel and lives in an apartment complex, and that same exact make and model shovel he's seen buying the morning after Emily's disappearance is found discarded next to his apartment building with dirt still on it. And we also have the fact that Emily's gravesite is located less than 1 mile away from his apartment. So we have that additional evidence as well. And circumstantial evidence and direct evidence are treated the same.
Was there a motion to suppress on the CSLI data?
There was not, Your Honor.
Did the defendant object to the introduction of any of the CSLI data at trial?
No, he did not, Your Honor.
How does that impact our review here?
Well, so the defendant in this case has completely waived appellate review of the CSLI data. It depends on, so the Fourth Amendment claim, that's completely waived for appellate review under a Supreme Court's decision in Miller that says you have to file a pretrial motion to suppress on constitutional grounds, otherwise you completely waive review even for plain error. In this case, so her fourth issue presented is completely waived under Miller. And then the fifth issue presented deals with the Confrontation Clause and the hearsay challenges. And again, she never raised any objection to the admission of evidence, so she's failed to preserve it under Rule 10. She never specifically objected on constitutional grounds, and that's a separate waiver matter. Constitutional issues not presented before the trial court are waived on.
That would just be an IAC claim down at the trial court if they wanted to try to do that, because they wasn't objected to. So what error did the trial court make in allowing this evidence in if there's no objection?
Exactly, that's right.
Mm-hmm. Okay. So why is this search warrant of the cell phone okay? Because I'm reading it and I'm looking at the affidavit. I'm not sure if I see a crime, but in the actual warrant, guess this is Graham Shirley that signed it. This is back in, I'm looking at the 2021. Says there's that evidence of a crime could be found. I mean, I guess you don't have to articulate what the crime is, but, or do you? I mean, tell me why this first search warrant's okay, or why we shouldn't care.
Sure, Your Honor. And so I think one thing to keep in mind with search warrants is that because of the preference accorded search warrants, we want officers to go to a judicial official and get a warrant without conducting a warrantless search. We afford great deference to the judicial decision maker's decision. And so we look at everything, all the facts alleged, and we understand that officers are writing these things quickly in the heat of an investigation and don't have time to sit there meticulously like we can behind computers and really write everything out. And so we understand that officers are writing these things hastily. And also, in the situation that we have here, we have an exigent circumstance of trying to locate a missing person that the affidavit establishes is known to be missing and believed to be endangered. And we have evidence that she was last with her abusive boyfriend who had physically abused her in the past. And we also have the evidence from the CSLI data showing that she traveled southbound on the 540 and then depicting the defendant's vehicle despite his claims to police that he just went home and the last time he saw her was when he left his mother's house.
If somebody's missing and there's nobody thinks it was foul play, they're just missing, and they think that there's evidence at my house that might help them find this person, can you execute a search warrant to go search my house to help them find this person? Or do you have to have some kind of crime involved?
Your Honor, I think you would have to have some sort of showing that the search would uncover some sort of criminal activity. And so in this case—
So what's that alleged here?
So we have that from the allegations of physical abuse and the fact that it's a domestic relationship, and the fact that she's missing and she's believed to be endangered. And also we have the text message, that last text message she sends her friend before her phone turns off indefinitely is that he's going to kill me, referencing the defendant. All those things together, when we think about the inferences that we allow magistrates, or in this case a Superior Court judge, to draw in order to reach probable cause for a search warrant, it's more than sufficient.
Well, how does his untruthfulness, is that specifically alleged in that 2020 search warrant, and how does that impact the probable cause analysis?
That's correct, Your Honor. It's alleged in there, and that also adds to the finding that there would be probable cause because if he were truly interested in finding his missing girlfriend, an officer might think that he would tell the truth about when the last time he saw her was. So that adds to the calculus of probable cause and him being a suspect in this known missing and believed to be endangered person's case.
So they had at that time the information about his car traveling and her cell phone ding in his car.
So I don't know that they had information about if you were to take CSLI.
So what was the lie in the search warrant? What was his untruthfulness in the search warrant that was left?
So they were able to tell his untruthfulness at the time this search warrant was issued on 12/4 based on his CSLI data. I think a few days later is when they actually got the photo from the Turnpike Authority showing his car traveling the other way. But that would have likely been found anyway because they're tracking Emily's phone and they would be looking at what vehicles possibly she could have been in at that time that she traveled that distance.
So at the time of the 2020 search warrant, he had told law enforcement that he was in one place when they knew he was actually at another place.
That's exactly right, Your Honor. That's exactly right. And that was also alleged in the affidavit, which again adds to the finding of probable cause, which for a search warrant, we have to remember, we're not looking at this de novo like a warrant search from an officer, which we look at de novo, but we're looking at it from the great deference that we always accord magistrates because we want officers to get search warrants.
Okay, now address her overly broad. It wasn't particular enough.
Sure, Your Honor.
Go search the whole house where only the attic would have been appropriate.
Sure, Your Honor. So initially I would say the defendant never raised this argument below, and so she's waived appellate review of that issue on appeal. At the motion to suppress stage, the defendant's entire argument focused on the particularity of the iPhone, the identification of the phone. He claimed that the warrant was insufficiently particular because the number listed for the iPhone was incorrect, And then also because it listed a iPhone 11 when it was in fact an iPhone 11 Pro 2. Those were his claims at the suppression hearing. And those are the claims that the trial court's findings reject. The trial court didn't make findings on the scope of the digital data searches because the defendant never raised that below. So given that that was never presented to the trial court, under Rule 10, it's waived. Also that the trial court never ruled specifically on that, which that's the second requirement in Rule 10. You first have to raise a specific objection,
So the
and
trial
then you have
court
to get a
again
ruling.
made no error because it wasn't brought to the trial court's attention. So this would be something else that might be for an IAC claim, perhaps.
It could be for an IAC claim, but just as the state has argued in their response to the appellate MAR, it's also apparent from the record that this issue was unpreserved. And so the defendant could have raised that IAC claim in her direct appeal brief, but she has not. And so,
Is it your contention that the MAR is improperly filed in this court?
Your Honor, yes, the state's contention is that given the sequence of events and what the direct appeal record shows, the MAR claims are all procedurally barred under the mandatory bar of Section A3. And the reason that's the state's position is because that's what the North Carolina Supreme Court decisions in Morrell and Price, and there was one third one that I cited. I can't remember. It's a 2000 case. Essentially, they make the point that an appellate MAR is not used to add new arguments to an appeal. And we know that you have to comply with the appellate rules. They're mandatory, not directory. Rule 28 says issues not presented in a party's appellant brief are deemed waived. You can't resuscitate unargued issue, for instance, in your reply brief.
Well, appellate MARs are hard because you typically would have to have a hearing and put the lawyer on the stand. Why didn't you make this argument? Blah blah blah. So is this something they could bring at the Superior Court later if we were to find no error?
Well, it would depend on how you handle the MAR. Because if you dismiss the MAR without prejudice for him to refile in the subsequent MAR in the trial court, then there would be no procedural bar. If you apply the procedural bar of A3 by saying you could have raised this in your direct appeal brief, but you did not, then they would be precluded from raising it in a subsequent motion for appropriate relief in the Superior Court. And so the sequence of events here I think is important. The defendant moved for an extension of word count increase of her brief from 8,750 to 15,000 words. This court granted 14,000 words. The defendant filed her brief, the state filed its appellee brief, and then the defendant filed this appellate MAR, raising new grounds or issues that were all apparent from the direct appeal record that she could have raised in her appellant brief.
Why wouldn't that be grounds for an MAR? That the appellate lawyer messed up.
That could be grounds for an MAR. That would be an appellate IAC claim. That's right.
But specific to the MAR that was filed, we didn't get into that much with opposing counsel, maybe on rebuttal. But I think the timing of the CSLI data and when it was noticed to defense counsel, could you address that piece of the motion for appropriate relief and whether there's some good cause there or not?
Sure. So I would initially start by saying that the statutes governing motions for appropriate relief 15A, 14, 15B provide the exclusive grounds a defendant may raise in an MAR. And one of them is that a conviction is obtained in violation of their constitutional rights. But it is not that a conviction is obtained in violation of a statutory right. And the defendant here is claiming that the state violated some statutory discovery, some discovery statute by not providing discovery within a reasonable time, I think the statute says. The state would dispute that because the state has filed a notice of intent to authenticate the T-Mobile records in the record on appeal, which was filed in maybe July 2023. And in that, the state says in their motion, these records were already provided to the defense during discovery. So the record undermines her claim that the state didn't provide those records. I think what her argument is that the state didn't provide State's Exhibit 29 during discovery. But all that she identifies, the difference of State Exhibit 29 was T-Mobile records that when they arrived, they came in in an Excel spreadsheet as requested. And the difference that she's identified in the State's Exhibit 29 records is that there's one file that says advanced correct dates, and there's another file that says other dates. And in what was requested was the dates from November 2nd until November 30th. And one of the spreadsheets has the dates from November 20th to November 30th. And the other spreadsheet has the dates from November 2nd to November 20th. And that's the only difference she's identified. And so anyway, they had
No
the
difference
full,
in the content. What was
exactly right. They had the full content of the T-Mobile records was given over in discovery, suggested the record.
It's just how the data was presented.
And the only difference is that half of the data was the state didn't feel it necessary to put all of the data in there when we were only concerned about looking at what happened from November 20th to November 30th. So we removed everything before November 20th. And so that hopefully addressed some questions about the discovery matter. And yeah, I would just reiterate that the defendant's claims could have been raised in her original direct appeal brief. There's several cases cited by the state that anytime it's a failure to object to evidence or a closing argument, it can be raised on direct appeal because we have the trial transcript typically, and we always typically have closing arguments transcribed. So that always could be raised on direct appeal. And there's a multitude of Supreme Court cases that the state has cited in their brief to support that position.
I guess my question here is that procedurally, isn't the MAR here really filed in the alternative, right, to the arguments made in the brief? I mean, the underlying substantive arguments, as far as the admission, the evidence and whether it constitutes plain error, are made in briefing. And sort of in the alternative, should we determine that it does not arise to a level of plain error and various other things, that these things kind of cumulatively result in ineffective assistance of counsel, which of course that's the constitutional right that's claimed under the MAR, is your constitutional right to effective counsel.
Mm-hmm. Your Honor, I would say two things to that. The first is she could have just as easily put in her appellant brief IAC. There's no, she already had, and the second thing I would say is that was only for 2 of the 9 claims that she raised in the appellate MAR. Those other claims were raised on grounds or issues that were never addressed at all in the brief. For instance, the failure to object to alleged inadmissible hearsay, that was never raised in the brief. The failure to move to suppress his custodial statement from December 9th, 2020, that was never challenged in the brief. There was only 2 grounds that she challenged in the brief alleging plain error, and those dealt with the admission of the CLSI data. So those 2 attendant IAC claims would maybe fit your scenario, but the other ones would not. She could have challenged the underlying ground or issue of those claims in her direct appeal brief, but she did not. And Your Honors, if there are no further questions, I'll just wrap up briefly. The evidence in this case of the defendant's guilt is overwhelming, even if we take out the CLSI data, or if we take out the data from the cell phone searches. And I went through that before, so I won't do that again. But
so you're saying if we took both those out, there's not a reasonable possibility that one juror might have found reasonable doubt?
Well, Your Honor, I'm not sure that's the standard reasonable possibility. It would be the standard if she objected at trial, but She did not. So we would be looking at whether
So
the
she didn't object.
CSLI data.
She didn't object to this. Did she object to the cell phone data at trial?
No, Your Honor, not that I had identified, and I'm not entirely sure what exact phone data she is objecting to. She was
The
arguing
searches, how to find how to dispose of a body.
that was never objected to, and the cell phone GPS fix locations, those were never objected to. So if those are the two items that she's now challenging should have been suppressed because they were prejudicial, those also would be reviewed under plain error because she never objected to the admission of those contemporaneously as required under our rules.
At trial. She did before trial, but not at trial.
So she never filed a pretrial motion to suppress the CSLI data, and then she never objected when the CSLI data came in. She filed a motion to suppress the data extraction of her cell phone on different grounds, which was denied, and then that had, the evidence that she now says was damning from that search, that was never objected to when it came in at trial.
Okay, so then we would just have to say, was there a reason, would the jury probably come to a different result had they not heard any of that stuff?
Then I think
based on
you would
all
be
the other
operating
stuff?
more under the plain error standard because it wasn't preserved by objection.
Based on the fact that he had the shovel, went to Walmart and washed his car and did all this other stuff and had an abusive, well, there was evidence of an abusive relationship, but, okay.
That's right, Your Honor. And aside from the text message, there was evidence of abusive relationship. And so, yeah, if this court has no further questions, the state would respectfully ask that this court find no error below and also to apply the procedural bar of A3 to the claims that could have been raised in her direct appeal brief, which the state would contend were all of them because they were based either on the trial transcript for failures to object or either to the evidence or the prosecutorial argument. The prosecutorial argument claim, too, also was can be resolved by the record because she argued the prosecutor was improper for arguing facts not in evidence, and as the state submitted in its reply, the evidence actually was, the fact that she claims was not in evidence actually was in evidence. There's an image of the defendant from the car wash, second car wash of the day, in his left front pants pocket appears to have what looks like a utility knife or a pocket knife clipped to the inside. So her argument is the prosecutor's argument was improper because there was no evidence that he had a knife in his pocket or at any time or had a knife at any time. So that would overcome both of those claims. And then also the recorded interview claim, counsel was ineffective for failing to move to suppress that. The recorded interview was admitted as an exhibit and made part of the record on appeal, and in observing that interview as the state put out in its response, we can see that the defendant, he did invoke his right to have counsel present initially, but then he immediately waived it and continued his conversation with the officers. So that, again, is another issue that she could have raised on direct appeal because all of the requirements for resolving that appeal were in the direct appeal record from the trial transcript and the video. And if your honors have no further questions this time, I actually will conclude and respectfully request that the state, that this court find no error below. Thank you. And then also apply the procedural bar to the MAR claims. Thank you.
Your Honor, I just have a few points to make in rebuttal. The first is there was, in fact, an objection at trial to the introduction of the cell phone extractions. And I looked that up because there was some question at trial as to whether that had happened, and it's at page 1163 of the transcript. The defense counsel does object when the telephone extractions are admitted into evidence. Then they object again when portions of those extractions, including the deleted searches are.
Was there any discussion of the trial, like statement, like what the grounds of the objection were? Was it just object?
They say object on prior grounds, Your Honor, and I believe they were referring back to the motion to suppress. I also just want to point out the problem with State's Exhibit 29. It's not simply that files were reorganized. There is missing data. If you look at what is alleged to be the timing advance records which are included in States 29, which were allegedly the underlying data that Agent Putnam relied upon, they're not in States Exhibit 29. The timing advance records, which I include as an appendix to the brief, jumped from 8 p.m. on 11/27 to 8 p.m. on 11/28. The timing at which the data that Agent Putnam claims to rely on, which is what happened overnight on that Friday night, are not in States 29. And you cannot confront what you haven't been given. And whether or not that is plain error under the Confrontation Clause, or whether or not it is a due process clause violation because the state didn't give it to the defendant, or whether it's ineffective assistance of counsel because defense counsel didn't realize they didn't have it, that can't be right. This is the most critical error that was evidence that was admitted against the defendant, and it is not there. The underlying data is not there. One option this court has on the MAR is to remand for an evidentiary hearing. And that is one of the key questions, as Mr. Jacome's counsel, that I would love to ask. Where is that data? Did defense counsel ever get it in discovery? And what did Agent Putnam rely upon if it wasn't State's Exhibit number 29? However you cut it, that has to have made this trial unfair. And finally, before I stop, I just would like to address the reason that I raised ineffective assistance of counsel, not in the appellate brief, but in an accompanying MAR, is because this court's precedent and our Supreme Court's precedent have strongly recommended that you raise ineffective assistance of counsel claims in MARs. And the reason for that is that there's always a presumption that defense counsel had a strategic reason. The record alone, and many of this court's cases have dismissed without prejudice IAC claims raised on direct appeal. There's a presumption that defense counsel acted strategically or with tactical reasons. And what the affidavits include, and that's what I got between filing the appeal, the brief, and the MAR, were those affidavits from counsel admitting they were inexperienced and overwhelmed with too many trials and unprepared. And they did not have strategic reasons for many of the things that they failed to do in this case. I would also point out that in the MAR statute, there's an explicit provision that says when you raise an ineffective assistance of counsel claim, you are waiving your attorney's, the attorney-client privilege with respect to that claim. I believe we should be very hesitant as appellate attorneys to raise IAC claims in direct appeal when we haven't talked to the client and said, you're waiving this, and we haven't talked to defense counsel and said, and given them an opportunity to respond. And that's why I believe the appropriate vehicle to raise ineffective assistance of counsel claims is the MAR. And if there are unanswered questions, then one course of action this court has available to it, and there are, in my mind, a lot of unanswered questions, would be to remand this case to the Superior Court for an evidentiary hearing on the IAC claims and the prosecutorial misconduct claims. Frankly, the IAC claims are significantly stronger in the motion for appropriate relief. Thank you very much for your time today, Your Honors.
Thank you both for coming and for your great arguments. We will take it under advisement. At this time, we will adjourn, but we have a special ceremonial session that's going to take place about 5 or 10 minutes, so we'll give you a chance to wrap up. So will you adjourn court? We may just stay here. We may stay here though. But go ahead and adjourn.
All rise. This session of the North Carolina Court of Appeals is now adjourned.